discuss restoring the people's power, the de jure grand jury, and jury nullification, and what they are. Now, I want to start off with a quote from Albert Einstein. He once said, "Information is not knowledge. The only source of knowledge is experience." Now, I want you to let that sink in for a moment. Information can be memorized. It can be taught, it can be copied, it can be rehearsed, but knowledge, real knowledge, must be lived. It must be experienced. It must pass through the fire of awareness and responsibility and truth. And that's what has been stripped from the people in our so-called justice system. We've been taught about our rights, about the Constitution, about the courts from school. But the very few have actually experienced the raw, living knowledge of true justice as it was intended by our founding fathers, which is the power of the people to hold government accountable through a de jure grand jury. Now, from Corpus Juris Secundum, volume 38A, it is the legal encyclopedia used by attorneys, judges, and courts across the nation. There is a sentence in that encyclopedia that changes everything. And that sentence says, there cannot be a grand jury de facto when there is a grand jury de jure. Okay, what does that mean to people who are not familiar with these terms and with the legal and law system? Well, de jure versus de facto. Let's get into that little battle of legitimacy. So de jure means by law. Okay, it's legitimate, lawful, rightful. It's rooted in the Constitution and natural law. De facto means in fact. It operates in practice but without lawful authority. It's power without legitimacy. Authority assumed but not granted. So when Corpus Juris Secundum tells us that a de facto grand jury cannot exist when a de jure grand jury is in operation, it's sending a very powerful message to those around the world. The moment the people lawfully stand up, organize, and reestablish their rightful grand jury by reassembling our states, any existing government imposed version of that grand jury is nullified, canceled, stripped away of legitimacy. Because the highest authority in a republic is not the state, although the state has more power than the federal government, but it's the people. Now, why does this matter so deeply? Most Americans today believe justice flows from the top down. Judges, prosecutors, bureaucrats. But that's not how it was designed. The original grand jury system was meant to flow from the bottom up. The people were supposed to investigate government corruption. The people were supposed to serve as the final check on abuse. The people were supposed to hold the gavel of truth. But what have we seen instead? Closed-door grand juries controlled by prosecutors, indictment driven by politics, not principle, and a public that no longer even knows that they even have the power to assemble their own grand jury by law without permission and with full authority. So how do we get back to restoring the de jure grand jury? This isn't about rebellion. This is about restoration. restoring the proper balance of power. And this doesn't need to be complicated. It doesn't need to be convoluted or confusing. Anything that is of truth and of God should be simple. That doesn't mean it's going to be easy to execute, but it should be simple. Anything from evil or Satan or the devil likes to add a lot of fluff and a lot of confusion and a lot of deceit, and yeah, he likes to spread a little bit of truth in there, but he also likes to mix in some falsities. When the people lawfully convene a grand jury under common law, when they follow constitutional principles, establish a proper power structure, and act in good faith, the grand jury becomes de jure. It is the only legitimate authority in the land to investigate, to indict, and to check the government. Now, the de facto system. The mockery of the justice system behind locked doors and corrupted prosecutors. It has no standing. It's not morally correct. It's not constitutional. It's not lawful. Because again, there cannot be a grand jury de facto when there is a grand jury de jure. But see, there's more to this. This is the power that they, being the elite, the de facto corporate structure that likes to tout themselves as the government, there is a power that they don't want you and I to know. You want to know what that power is? It's very interesting. There's a deeper layer to this conversation, one that most courts and legal professionals never want the public to understand, and it's the doctrine of jury nullification. So what is jury nullification? Let's talk about that for a moment. So, jury nullification is the power of a jury to refuse to convict, even if the evidence clearly shows the defendant broke the law, because the jury believes the law itself is unjust, unconstitutional, or being applied unjustly. It's not a loophole. It's not a glitch. It's a feature of the justice system, a direct line of power from the conscience of the people to the outcome of a trial. In fact, it's a form of peaceful resistance built directly into our judicial system. The founders knew that laws over time could become corrupted or even weaponized, and we certainly see that. So, they made sure the people would always have the final say. There's a historical power there that has since been hidden. See, in early American history, juries were told of their power to judge both the law and the facts. John Jay, the first Chief Justice of the United States, instructed jurors in 1794. The jury has a right to judge both the law as well as the fact in controversy. But see, over time, especially during the 20th century, the truth was buried. Judges began instructing jurors that they could only consider the facts, not the fairness or constitutionality of the law itself. Now tell me, where does a judge get off telling jurors what they should be judging? Because the judge, just like a president, just like a senator, a statesman, they are public servants. Either elected or appointed, but they are public servants. We have a constitution for a reason. That is to provide the enumerated powers that they need to stay in their lane and not go beyond their lanes. Because the people back in the day, created the Constitution. So why do judges do this? Because an aware and empowered jury is a threat to illegitimate power. That's why they do it. Now, there's a book that's called The Constitution That Never Was by Ralph Beresczewski. And if I butchered that name, my apologies. But what Ralph outlines here is how our constitutional government was subtly overthrown through a series of legislative and procedural tricks following the Civil War. He argues that the original Constitution, rooted in individual sovereignty, common law, and decentralized power, was replaced with a corporate top-down system, again, masked in legality, but divorced from lawful authority. Figure that one out. And what was one of the first casualties in this transition? The power of the common law jury. The book details how courts and legislatures began stripping away the people's ability to control their juries, select their own peers, and exercise jury nullification freely. They replaced lawful courts of record with administrative courts. They replaced de jure institutions with de facto systems. They replaced justice with procedure. So why is jury nullification so important right now? It always has been, really, but more than ever right now. Jury nullification is not an act of rebellion. It's an act of moral conscience and constitutional duty. It protects against tyrannical laws. It empowers the people to stop injustice at the ground level. It makes the people, not politicians, the final authority on what is just. And when combined with the restoration of the grand jury, the de jure grand jury, we create a system where the people investigate, indict, and even nullify laws that violate the higher principles of liberty, freedom, morality, and, dare I say it, truth. This is what terrifies the system. This is why they don't teach it in schools, along with a lot of other things they don't teach in the public indoctrination system they like to call schools. This is why judges lie to juries about their true power. Because if the people ever remembered who they are, it's game over for the tyrants. Game over. So, back to the core. Experience is ownership. Let's go back to what Einstein said. Information is not knowledge. The only source of knowledge is experience. You've now received the information. You've glimpsed the truth behind the veil. But the only way this becomes real is if you experience it, study it, speak on it, stand on it, assemble, and act. Because in the end, remember, there cannot be a grand jury de facto when there is a grand jury de jure.